All rise. The Supreme Court of Guam is on session. The Honorable Chief Justice Robert J. Torres presiding.
Afternoon, good morning. You may be seated. Before I ask the clerk to call the case, I want to say hafaday to the councils and to our special guests in the audience today, the mock trial students from Guam High School. And there were supposed to be Academy of Our Lady students here, but I don't see them here right now. Some of you met me yesterday. I'm Chief Justice Robert Torres, and along with my colleagues, Justice F. Philip Carbolito and Justice Catherine Merriman, we welcome you back to the Supreme Court of Guam. Each day, more than 30,000 judges and justices throughout America ensure that our nation continues to be ruled by the law and that everyone is equal before the law. One of the most effective ways to promote public understanding and commitment to preserving the rule of law is for the public to meet with judges and bear witness to their commitment to fairness, impartiality, and the rule of law. As we celebrate National Judicial Outreach this week, we invite members of the community to our courthouse or to our YouTube channel for those watching virtually to see their judges and justices in action. For the mock trial students today, you'll have the unique opportunity to see what happens next, what happens after the trial is over. When the trial's over and the judge or the jury has ruled on a case, parties who may not be happy or satisfied with the outcome can appeal to the Supreme Court. Unlike cases in the Superior Court or in your mock trial, an appellate hearing does not involve taking evidence from witnesses or viewing exhibits, and there are no jurors here today. Instead, the issues that are before the court are argued by the attorneys here, representing both sides, and the justices will ask the attorneys questions about the law and the record pertaining to those cases. We believe that your mock trial experience will give you a good foundation on some of the issues you'll be hearing about today. In fact, one of the issues concerns hearsay, standard mock trial objection, and the admissibility of evidence in the trial court or whether it was subject to a hearsay exception. And hopefully you'll come away from today's hearing with a greater understanding of and appreciate the legal system and the rules that govern it. I'd like to thank both counsels today for Mr. Randall Albright representing the people of Guam and Attorney Brian Eggleston representing Mr. Soram for graciously agreeing to spend a few minutes answering some of the questions after the hearing. So we'll now begin with today's hearing. Will the clerk please call the case?
This is Supreme Court case number CRA23-005, People of Guam, Plaintiff Appellee, v. Joyner Anis Soram, Defendant Appellant. Appearing for Plaintiff Appellee is Attorney R. Winston B. Albright. Appearing for Defendant Appellant is Attorney Brian P. Eggleston. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Eggleston reserves 5 minutes.
You may proceed, Mr. Eggleston.
Good morning, Mr. Chief Justice, and may it please the court. Before turning to the 4 errors pressed in this appeal, I want to give a brief bird's eye view of this case, both for the benefit of our spectators and also to provide some context for the issues raised in this appeal. Mr. Robert Bloss was walking home one evening. According to trial testimony, he was approached by 2 guys on the street. What followed was what one witness described as a scuffle. Out of this scuffle, Mr. Bloss lost his watch, and ended up with a bruise on his upper left thigh. Cases like this are the bread and butter of the trial court. They routinely resolve themselves either after trial or through a plea agreement in sentences of probation or, depending upon criminal history, sometimes a year or two in jail, followed by 3 years of parole. What makes this case such an outlier is that under Guam law, the addition of one fact, the possession of what appears to be or is a deadly weapon, changes a case that would normally resolve in a sentence of maybe a year or two, turns it into a case that requires a minimum of 10 years and the maximum going into the 30-year range, maybe even greater now that I think about it. In this case, one thing is not at issue. We are not contesting the sufficiency of the evidence to find a deadly weapon. I think that argument is foreclosed by this court's case last term in Tysican. But assuming that a jury could rationally find the existence of a deadly weapon in this case, I think it's equally plain that a rational jury could look at the circumstances under the three-part test laid out in Tysican and find that when a baseball bat is used to strike someone on the thigh rather than in the head area, it is not the possibility of death or serious bodily injury is so remote as to render it not capable of causing death or serious bodily injury.
I know you made an argument that if you rejected the government's argument that it is per se impossible to use a baseball bat as a weapon without also using it as a deadly weapon. And the government seems to say, well, automatically the baseball bat was a deadly weapon, or at least you took issue that that was their position. And you said it would render the distinction between bodily injury and serious bodily injury meaningless if that was the case. But the government argues that he was charged not under the provisions of A1 and A2 of 9 GC 8040.20 on the robbery provision, but under the deadly weapon provision of A3 and 80.37. So does the manner in which it's charged make a difference in terms of the proof that's required?
It certainly does make a difference. It does not change our argument here because ultimately the proof required is that depending upon whether we're looking at the special allegation or the element of the second degree robbery itself, a finding is necessary that the baseball bat either appeared to be for the second degree robbery charge or was for the special allegation a deadly weapon. And that is defined by statute to be, and actually clarified in this court's Tysican case, to be first used or intended to be used in the manner of a deadly weapon or dangerous instrument. Second, used or intended to be used in a manner capable of producing death or serious bodily injury. And third, that the defendant knew that the manner in which it was used or intended to be used could produce death or serious bodily injury. In this case, we know that the manner in which it was in fact used was capable of causing bodily injury. It did cause bodily injury, a bruise to Robert Bloss's upper thigh. However, the statutory definition of serious bodily injury requires significantly more. It requires permanent disfigurement, protracted unconsciousness, or death. And
doesn't it also just require serious pain?
It also could be serious pain. At issue in the, excuse me, let me refresh my memory of the name, the Ramey case, the actual element at issue was whether serious bodily injury was suffered, not the possibility of it. But even where there was evidence that, in fact, uncontested evidence that the victim suffered fractures of his facial bones, the court found that a reasonable jury could find that it did not rise to the level of serious bodily injury. And so even that could fall within the range of pain that does not rise to serious pain. Again, we're not contesting that the jury could find that it was capable of causing serious pain, only that a rational jury could find otherwise as well. And I think that the main reason behind that intuition is that it is simply a matter of fact about the human body, that it has one particular place that is incredibly susceptible and in some ways uniquely susceptible to blunt force impact. Anything that hits someone's head has the possibility of causing brain injury, which in turn has the possibility of causing death. That is not true of someone's arm or leg. And so pretty much any heavy, solid object, if directed with sufficient force at someone's head, could produce death. But we don't, in our ordinary language, say that someone's use when they're hitting a leg or an arm.
So if we were to view the bat used in this case, and you're saying that it is not capable of causing serious bodily injury, and as it's defined in reference to the facts of this case. So would that also affect the conviction for aggravated assault? In that case, the jury was given the instructions regarding serious bodily injury, deadly weapon, the use of the bat, instructions for both aggravated assault and misdemeanor assault. And there, the jury came back and found him guilty of aggravated assault. So would that conviction also go out the window in reference to your argument as to that the bat was not used as a deadly weapon or cannot be viewed as a deadly weapon under the facts of this case?
I think if the court were to vacate and remand for retrial of the second-degree robbery conviction, vacater and remand on the aggravated assault and assault convictions would also be warranted. The reason for that is that.
But you didn't ask for that in your briefs, did you?
We are asking for reversal of the convictions in general. I think depending upon what basis the court were to reverse on, retrial would not necessarily be precluded.
Would we be substituting our view of the facts in reference to how the bat was used for that of the jury? Would our standard of review on appeal permit us to replace how it's viewed, how the bat was used in this particular case, whether or not it was capable of causing serious bodily injury?
I think it is not necessary for this court to replace the jury's finding of fact. And in fact, it is the very latitude given to the jury in finding facts that I think supports the reversal and remand here. A rational jury could have found a joiner guilty of third-degree robbery without having to find that there was a deadly weapon. The government's argument is essentially that the jury does not even have the latitude under the state of the evidence to reach such a verdict. I think it's actually the wide latitude of the jury's fact-finding capabilities that says that they should have been given the option of convicting on just third-degree robbery, misdemeanor assault.
But the government argues that even if your argument is correct, that the trial court committed error in not giving the third degree robbery instruction. This is a plain error review that is it is subjected to because there was no objection at the trial level in reference to the not giving the jury instruction. And so when the government argues that there is no substantial prejudice because when the instruction was given in reference to the use of a deadly weapon as it pertains to the aggravated assault charge, the jury found that the facts support a conviction for aggravated assault. And so if in that vein, what is the substantial harm that the instruction was not given when the jury had already indicated that their view is that the bat was used as a deadly weapon in reference to the aggravated assault charge?
And I think the prejudice is best understood in the context of both the Ramey and the Angoko decisions, where the court recognized that the jury found all of the elements of the crime on which they were instructed. And of course, they had the option of not finding one or more elements met in both of those cases. But the actual prejudice was that the jury itself, in finding what the facts were, was placed in what the court referred to as an all or nothing. But even in Angoko, I believe they convicted on one charge and acquitted on another, and the court said that would not have changed its decision. But ultimately, the jury's finding of the facts to be done properly requires them to have the full range of verdicts so that they can select the set of verdicts that most properly reflect the culpability of the defendant. In this case, there was very significant evidence that a robbery had occurred. There was direct testimony that a watch was taken and that the victim of that theft suffered a bruise on his thigh as a result of the theft. And so I think it is very plausible that a jury would look at those facts and say it would be too lenient to acquit of robbery altogether, even if we were to convict on the assault charge. And so they were, because of the lack of a third-degree robbery instruction, they were forced to choose between either acquitting on robbery altogether and then perhaps convicting on assault, or finding that the deadly weapon was used, which would allow them to convict on the second-degree robbery charge. But also, as I think the government concedes in its opposition brief, really required from that point forward that every special allegation and every other charge be a conviction, because the only thing that separated all of these other charges was the presence or absence of a deadly weapon. And so it's the very fact that Ms. Joyner did not have the opportunity to ask to be held responsible just for a robbery that resulting in minor injury along with assault, and that the jury instead had to choose between a set of verdicts with a 10-year mandatory minimum or acquitting him of robbery altogether and maybe convicting on the assault charge. I think it is, and in terms of the prejudice, the court's analysis in Ramey and Angoko is instructive.
Before you go on, if the jury went ahead and convicted on the assault charge, their only choice would have been the aggravated assault.
So they, if they had not convicted on robbery, they could have found him guilty of just misdemeanor assault.
Simple assault, yeah.
Yes, or they could.
Could they have found him guilty still of the aggravated assault if they found him not guilty on the robbery?
They could. I don't know that the evidence supported a finding that the watch was not taken. But I suppose in a criminal case, the jury can always choose to disbelieve any particular piece of evidence. And so theoretically, at least, the jury could have discredited the evidence that anything was stolen while also finding that the scuffle resulted in a bruise. And based on that, the jury could have convicted on just assault without convicting on robbery. I think it unlikely given the state of the evidence, but it would not be impermissible. And in Angoko and in Ramey, when the court was looking at whether the absence of this lesser included instruction was prejudicial, the court did not find it necessary to try to guess what the jury would have done if they had the full range of options available. The court simply said, it is plausible on the current record that a jury could have found that the lesser included offense was sufficient to match the culpability of the defendant without requiring the greater offense to be a conviction as well. That is the same prejudice that we're claiming here. I think especially in light of the minor injury that is nowhere near the victim's head, a rational jury could say, yes, this was a robbery. He hit him with a baseball bat. He caused some injury. He used force. He stole something. But there really was no realistic chance of anything more than a bruise occurring based on this scuffle. And based on that, a jury very plausibly could have found that the third-degree robbery and misdemeanor assault taken together were sufficient to match Joyner's culpability. I think in terms of the prejudice and the reversal being required to avoid a miscarriage of justice, in both the Angoko and the Ramey decisions, those two analyses really do dovetail. In a lot of ways, the prejudice, which is the deprivation of having a jury able to decide from the full range of options, is also what the court identified as requiring reversal, because the fundamental fact finding of the jury was impaired by not having all of the options available to it, just as was the case here.
You keep saying that it was a minor injury. Doesn't the evidence indicate it was very traumatic, a serious emotional, so to speak, injury for the victim?
I believe that a scuffle, especially when it's two men against one, is emotionally traumatic no matter what. I think it, but that is not necessarily the same as saying that the physical injury was serious. I think much of him being shaken up was about the fact that he was being attacked and robbed by these two guys. And I realistically could see myself being shaken up even without suffering any injury whatsoever. So I think the rational jury could still have found that he was incredibly shaken up and emotionally distraught, and found that this was a minor injury with no real chance of anything more serious. I think that that issue also, the issue of the lesser included, dovetails with our ineffective assistance of counsel claim, because frankly, even without the lesser included instruction, trial counsel's decision, which I'm sure he believed to be a strategic one, is really inexplicable in light of the trial record. He essentially conceded to the jury that if the bat was used as a weapon at all, then it was necessarily used as a deadly weapon. He told the jury that Joyner was holding the bat and still holding the bat at the time when the police found him. And ultimately, the only real point of doubt that he attempted to press was that maybe the victim was confused about what happened and he didn't really get hit with a bat. That is, I think, unjustifiable when there is physical evidence that he suffered a bruise, and the most natural explanation for that when someone was holding a bat during the scuffle is that the bat caused the bruise. I think perhaps the most plausible explanation of why trial counsel might have pursued that strategy was that he had not looked up the sentencing exposure before trial, and that therefore he was just unaware that the mandatory minimum on the second-degree robbery was going to be at play. And so he thought it was reasonable to shoot for an all or nothing strategy, asking for outright acquittal. Having reviewed the entire trial record, I cannot come up with a defense of that, knowing that the statutory mandatory minimum is in play. I think any competent defense counsel would recognize that at least the jury needs to be given some option of holding him accountable without bringing a 10-year mandatory minimum into play. And that was just not pressed. And instead, basically, all of the elements of the crime were conceded by trial counsel during closing argument. As I noted, he may have felt somewhat constrained by the absence of any third-degree felony instruction. But I think whether the lack of that instruction contributed to this indefensible closing argument, it really cannot be justified by any rational, legitimate strategy of trial counsel. Moving back to the issue of
Normally, we leave for whether counsel was effective or not for a writ of habeas corpus and don't generally, unless the record is complete before us, for ascertaining whether counsel's performance was effective or not.
That's correct. And I think first, the court, of course, has the discretion to review it on appeal. Normally, they are preferred through original jurisdiction. I think the reasons that a writ of habeas corpus would not add anything to the analysis in this case are twofold. First, that the failures of trial counsel are based solely on the trial record. And second, unlike in many cases, there's really not going to be much opportunity for discovery regarding the bases of trial counsel's reasons for his decisions. He unfortunately passed away while this appeal was pending. Which
That was going to be my next question, how, considering the fact that counsel has since deceased, what would be added by going forward with it?
And I think that's really, if this were brought as a writ of habeas corpus, it would look exactly like this appeal currently looks. There's really not much fact finding that could be added to it. With respect to the trial courts,
I guess the defendant could testify.
the defendant certainly could testify. I don't, of course, he would have to waive attorney-client privilege and to testify about what their discussions were, and to the extent that he has any hypothesis about counsel's reasons for that strategy. With respect to the trial court's rulings on the two defendants' motions for judgments of acquittal, as I mentioned in my opening brief, my personal view is that the possibility of the bat having changed hands between the scuffle and when they were found by the police really precludes a finding beyond a reasonable doubt that Joyner was the one holding the bat. But I don't think the court has to go so far as completely agreeing with me that the motion should have been granted in order to reverse here. It is sufficient to note that the co-defendant's motion was granted, and the only logical inference separating the two would be the inference that the bat may have exchanged hands between the scuffle and when they were found by the police. If the jury has given its wide latitude, if the jury has the ability to make that inference, then they necessarily could have inferred from the same facts that it was actually John Soram who was holding the bat during the scuffle. By denying Joyner's motion while simultaneously granting John's, he put Joyner in the even more difficult position of being the only person that the jury could even find was responsible for the robbery. And given the substantial evidence that a robbery had occurred, that a watch was stolen and that injuries resulted, they were very likely to want to hold somebody responsible for the robbery. And Joyner was denied the opportunity to essentially argue, you can't figure out which of the two of us did this, and therefore you should acquit both of us on this front. Finally, turning to the hearsay issue, it is really significant, I think, in this case that the one eyewitness to the scuffle affirmatively testified that he was unable to identify whether the two defendants sitting at the table were the same people he had seen that night. And when Robert Bloss took the stand, the government did not even ask him to try to identify who had struck him that night. And in fact, the only testimony he gave relating to identification during the trial was that the guy holding the bat hit him with the bat, which certainly left open lots of room for doubt regarding whether or not Joyner was the one at the time of the scuffle holding the bat. Here, though, the officer that interviewed Robert Bloss testified extensively to statements made by him at the time, which were unsworn and out of court, stating that the guy in the black shirt is the one that hit him with the bat. And as I mentioned in our reply brief, I think statements like the guy in the black shirt hit me with the bat do not qualify as identification testimony within the meaning of the hearsay exclusion to begin with. But even with respect to the one statement that was an identification, that he pointed at Joyner and said, that's the guy. In this case, all of the reasons surrounding that exclusion are not present here. We have circumstances of identification that were just as suggestive as anything in the courtroom. And one of the primary rationales behind this exclusion is that there's a reason to prefer earlier identifications if there are adequate safeguards against suggestiveness. But here it was just as suggestive. And secondly, given the voir dire and the way that went, I think both defense counsel were absolutely correct in realizing that there was that if they were to try to question him about statements made out of court, his responses might sound like they make sense in that he might say yes or no to various leading questions, but that they had no reason to believe those answers actually bore any meaningful relationship to the question itself. During voir dire, multiple questions were posed to him that he did not ask for clarification on, he just answered. And based on the context, we can see that those answers just were nonsensical or just completely false. But in the context of the actual trial, asking about this statement he made out of court, there's really no way for them to prove that whatever yes or no answer he gave was or was not correct. And so they would essentially be flipping a coin on whether his answers to questions about those statements were inculpatory or exculpatory. And so because they did not even have the meaningful ability to try to cross-examine him about these statements, I think the exclusion from the hearsay rule is not applicable. And I see I'm out of time.
Your time is up.
Thank you, Your Honors.
I'll give you 2 minutes on rebuttal. Mr. Albright.
Chief Justice, may it please the court. This case involves a 37-year-old man, Robert Bloss, on December 12th of 2022, walking home, where he is viewing two people across the street who approach him. One has a baseball bat and immediately begins to strike him. He's hit in his left hip, according to the testimony at trial. He testifies that he has a bruise in that area. He testifies that he then flees into Route 10 in oncoming traffic in order to escape. He testifies that he informed the eyewitness of what had occurred. At that point, he asked the eyewitness to call 911. At that point, Gerson Hobbing saw the altercation between the Soram brothers and Robert Bloss, as well as Bloss fleeing across the highway.
But Counselor, Mr. Eggleston's argument on the jury instruction that in reference to the third-degree robbery jury instruction that he argues that should have been given, he doesn't deny that there was a bat at the scene, but in reference to the roles that we have pronounced, there must be a substantial basis that would support substantial evidence that would support a rational basis to for the requested instruction. And in this case, he argues that the way the bat was used provided a rational basis that there was not a serious bodily injury that was caused, and that that there was a rational basis for the trial judge to issue or instruct on the third-degree robbery. And so it's not that there wasn't a bat or that he wasn't struck. And I think the example that he gave, the comparison of striking one with a bat over the head as opposed to, as you now mentioned, the hip, that may have provided a rational basis for the third-degree robbery jury instruction to be given in this case. And what's your response? That no, there's no rational basis for it?
Yes, Your Honor. First off, in our brief, we pointed out that there needs to be a request and a rational basis. Here, the charge was in that he rationally was armed. He was intentionally was armed with what appeared to be a deadly weapon, that is a bat. I'll just point out that we did cite.
Well, I don't think he denies that the bat is capable of being used as a deadly weapon. But in this particular case, under the facts, that may not be the case.
I think that there's a problem here, Your Honor, because in this scenario that defense counsel is trying to have the court adopt, the luck of the draw that the victim gets away without more serious injury would preclude any conviction under the statute. I don't believe that's what the statute intended here.
But then is it your view that anytime that a bat is used, it's automatically a deadly weapon, and that the deadly weapon jury instruction must be given, and it's not how it's used that matters?
Here, the bat is an instrument of the robbery, and it's used to inflict injury. That's undisputed, I believe. Counsel is saying that because he's not injured too badly, that there was no intent, or it can't be viewed as a dangerous weapon. But a bat, the destructive potential of a baseball bat is self-evident, as People versus Khan shows us. That's a 2023 case. And here, the luck of the draw that he was able to flee after viewing the bat, injured by the bat, property taken, is a justifiable, reasonable basis to fear that it is a deadly weapon, and it's well wielded as such. So I think that element is met, and from there, it was a proper instruction in the robbery and the second degree charge.
If the facts were a little different, that there was a bat and before he hit Robert Bloss, he was able to flee and he wasn't struck, would that made a difference in reference to whether or not a third degree robbery jury instruction should have been given?
I don't think that would have made a difference, because in this case, the facts are clear that it was during the course of committing theft of personal property, and that the finding of the jury in the second count of assault with the deadly weapon, aggravated assault, shows the rationale of the jury as well in maintaining the bat as a dangerous weapon. So I think to rob the jury of that conclusion also would strip them of the finder of fact in this case. So that would be the state's, or the people's argument rather. There is ample case law that the bat's capable of serious injury or death. Here, counsel would try to have you believe that bats are used traditionally and people aren't injured when they're swung, or that it's not per se a dangerous instrument. But here, when it's used in a robbery and injury occurs, there is a rational basis that that's a deadly weapon.
What about the distinction between serious bodily injury and, as pointed out by, counsel, and the definitions of serious bodily injury versus bodily injury?
So here again, basically, the statute would be gutted if we applied that standard, that, oh, the victim only suffered X, Y, and Z versus, oh, the bat contacted with the brain, for example, and there was a closed head injury. The statute is about how it is welded, and in this case, it clearly is swung several times to the victim, causing the injury. And it's also to facilitate the taking of the property. So here to apply, well, this victim's only injured, he has a scratch, this victim has is dead, this victim is brain injured. That would be not what the intent of the statute is.
Then why even have a different definition between serious bodily injury and bodily injury if it doesn't make any difference what results? The simple fact that he used a bat, swung it, and hit the individual is sufficient for it to be used as a serious deadly weapon, or as a, yes.
Well, here, the only element there is that the bodily injury was during the course of the robbery. So if we look at the second charge of aggravated assault, he did cause bodily injury to another. That's what the jury did determine. If I can move on to the next
I thought
argument.
the jury came back with a finding of aggravated assault, and that's a serious bodily injury, not just a bodily injury.
Yes, the jury did return a verdict on the aggravated assault with the special allegation.
So wouldn't that then by definition mean that it caused serious bodily injury?
No, it's only that it recklessly caused bodily injury at that point.
Wouldn't that be then simple assault?
No, because the aggravated assault is that he caused bodily injury to another with a deadly weapon that is a bat. So I think that allegation or that theory is not even argued by defense counsel in this case. I want to point out too that to then on the rebuttal argument or rebuttal brief, counsel's challenging the competency of the victim in this case. Now, the trial court had already heard testimony. The jury had taken in that testimony. There was questioning as to his competency of voir dire, and then the judge decided, based on the responses, that the 37-year-old man, Robert Blas, with special needs, was capable of testifying. So I don't think that the court would be furthering anything to second guess the trier of fact in that regard.
And you bring that up for purposes of saying once he was deemed competent, counsel then had the ability to subject him to cross-examination concerning the statement of identification?
Yes, I believe so. That's one point there. And what we also would argue under 801, that the statement by officer was Leon Guerrero was also not hearsay at that point, as it was one of identification. I want to point out that during the resuscitation of the facts, I wanted to go into the eyewitness's continual observation while he was on the 911 telephone call with officers, continually viewing the two suspects until officers arrived. So there were also three elements that the jury and the court could use to establish that it was not prejudicial with that statement coming in. Number one, the bat was in the hand of the defendant. Number two, the watch that was testified to, taken from the victim, which he described in detail as being a gift from his father for Christmas, was on the defendant. Number three, there was a black shirt on that particular defendant that was holding the bat as well. And that was the basis. Now, to just suppose that, oh, there could have been a switch of shirts or what have you, that was not found by the jury. So the constant surveillance, the 801 would get us over any hurdle there. And I would just point out that to bring up any new arguments on the rebuttal is improper because it presents issues on appeal that generally cannot be raised for the first time in an appellant's reply brief.
What do you suggest those arguments are?
I think the argument trying to bring up that there was no testimony by the victim would be one of them. But that testimony should be discounted because he's not competent. That would be imposing a new trier of fact, i.e. defense counsel on this case.
But wasn't he just addressing your argument that hearsay did not apply because it was not hearsay because it was one of identification made of a person after perceiving that person? So he was trying to show how it didn't fit within the rule because even though the declarant that has to testify at trial or the hearing and be subject to cross-examination. And so he was trying to bring up why he felt they weren't subject to effective cross-examination for purposes of that rule.
So once again, I would say that argument would be moot because there was a determination as to the credibility of the witness, the competency, the right to testify. And that is one thing that the jury has to take as they find them in the court as well. And here they did find enough responses from the victim to move forward and have him testify.
Can you address the judgment of acquittal, the arguments brought up by counsel that the basically removing the jury's ability to hold John responsible for the robbery necessarily eliminated Joyner's ability to argue for an alternative combination of the verdict, and he was sort of left with having to go proceed in the manner that he did because of the fact that denying his motion for judgment of acquittal prevented him from arguing the manner in which he could go forward.
Here, the trial court did not err in denying Joyner's motion for judgment of acquittal because there was sufficient evidence in the record already to find that the defendant, that the people of Guam had overcome the burden to proceed on after the JOA. Here, there was ample evidence from many witnesses that the person in the black shirt who took the wristwatch of the victim and the money of the victim and had a bat and was discovered with a bat was at the time of detention by the officers and under constant surveillance by the eyewitness, in fact, this defendant. So given those facts, I think the judge had enough evidence to rule that the JOA in regards to this defendant was denied. So there is a distinction, and it's factually based on what the judge
You said there were many witnesses. You're talking about the Mr. Hobing as the one who had testified that, and your recollection of the testimony that he had his eyes on the two defendants during the entire episode from the time he was struck. I thought he testified that he did not was able to identify who struck the victim, Mr. Robert Bloss.
He was able to stay on the phone, view the defendants, and stay in constant surveillance of them while the police were arriving.
As to their location.
As to their location and seeing the police appear and take them into detention. However, if he was close enough for his own safety to view and ID the particular defendants, that's not clear in the record. And I think we're left with the fact that.
So who are the other witnesses? You said there were many witnesses that was able to identify.
Well, Your Honor, if I may, the officer who detained the defendant and also was able to see the identification of the defendant via the victim, and the other officer who then arrived on scene as well. So we do have at least three that have personal knowledge, personal observations right there. So those are the witnesses I referred to. Your Honors, if I may address the Chief Justice and Justices, rather, thank you. If I may address the argument of counsel on ineffective assistance of counsel. I think this goes in line with the theory of defense counsel at the time of trial, that because the bat was undisputed, the injury was undisputed, that it was a very sound trial theory to make those arguments and make those concessions on elements of the crimes that they're not going to most likely succeed on. It happens time and time again to have concessions in a jury trial. And then from there, to make your arguments. So it was a sound theory.
Well, what would the theory have been if he was conceding that it was a deadly weapon? The theory would be that there was no robbery in the face of the evidence that there was this watch and he had possession of the watch? What would be the theory?
I think he does have a hard burden to overcome. And his theory is that the bat was not used in a manner that would indicate a deadly weapon.
But he didn't make that argument. That's what counsel's pointing out, that he could have argued in the alternative, even if he did assault him with the bat, that his use of the bat didn't satisfy the three elements for Tysican to make it a deadly weapon. I mean, that's what he's basically saying. He could have acknowledged there was a bat. He could have acknowledged, I mean, because the evidence was there was a bat, they found it, that there was a robbery, but that the use of the bat did not constitute a deadly weapon.
Here, I believe he does make that argument that it's a scuffle. That's what we're hearing time and time again in this case from defense counsels, that it's a scuffle, it's just incidental. The striking is not even occurring, is what he's factually arguing, and it's closing, I believe. So to concede that it's present and with the defendant was his strategy, and that it was a minimal bump with the bat or what have you. And here we hear that from defense counsel again on appeal, that, oh, this should be viewed as a misdemeanor, or what normally happens in these cases, which is the most far-fetched thing that I've ever heard, is that the jury would be looking at, oh, this is a 10-year sentence or not. No, the jury is simply finding the facts of the case. They're not making sentencing conclusions to determine those facts. So that would strip the constitutional right of the jury to make the fact-finding elements, fact-finding in this case, so that they can determine if these allegations occurred or not what the sentence is, or, oh, let's pick a lesser charge because this sentence is too high. No, that's not what they're deciding. They're deciding.
If he told, counsel told the jury it was clear that he possessed the bat, he told the jury that if they find that he used the bat in assaulting Blas, it would constitute robbery. And he went on to tell the jury that if he used the bat in a threatening manner, that it would constitute a deadly weapon. What arguments would he put forth to the jury in defense of Mr. Joyner?
I think that's a good argument, Chief Justice, because he could be saying that the bat was simply on his person. The injury occurred via a hand or what have you, or the bumping and the scuffle, which is exactly what the language is in the transcript that defense counsel makes. It doesn't sound that plausible to the jury, apparently, because they find otherwise, but that is what he was left with those kind of facts before him, I believe. And that would be a sound legal theory to go after. And we hear it again today, that this is just a scuffle versus an assault or an attack. So if there are no other questions, I would just conclude, if I may, that here, even if the instruction had been required in regards to the lesser included, Joyner had failed to show that the error affected the substantial rights, because when offered the opportunity to find that the bat was not a deadly weapon, the jury nonetheless found it so. That's one argument we make. I'd like to put that forward. And finally,
Well, the government says that the problem with that, I mean, the defense says the problem with that is that if the jury believed that simple assault or assault was not sufficient, there was actually a robbery. And so they wanted to convict him of robbery, but the only way they could convict him of robbery was to convict him of third-degree robbery, because they couldn't convict him of second-degree robbery without that lesser instruction, even though they felt that that might have been appropriate, because they didn't want to just let him go with a assault conviction. That's what he's arguing. So the idea that the argument that because the jury when the jury was offered the opportunity to find the bat was not a deadly weapon under the aggravated assault, they found it to be. But that might have been, as he points out, because they had already determined or wanted to determine that there was robbery, and the only way they could determine there was robbery was if a deadly weapon was used.
well, actually, I believe, Chief Justice, that they could also determine that the defendant was intentionally armed with what appeared to be a deadly weapon. I don't believe they'd have to, during the commission of the theft, versus that it was actually wielded in a manner of a deadly weapon, that it was intentionally in the possession of the defendant, i.e. he was armed with the bat.
So the argument is that anytime you're armed with a bat, it's a per se deadly weapon.
Well, here, I think that we do have other circumstances in this case. There's a wielding of it. There's not, it's immediate. It's upon the initial contact. It's used to take the property of the victim. It's used to take the wristwatch. It's used to take the $20. So this is a bit different in the actual facts that transpire. And at that point, I'll just conclude unless there's further questions.
I don't have any further questions. Thank you.
Okay, thank you.
Mr. Edelson, I gave you 2 minutes.
Thank you, Your Honor. First, I want to make clear that we understand that the jury is not considering sentencing in making decisions of facts, and that generally speaking, we do presume that they just find the facts and then whatever verdicts flow from it. However, it is an underlying premise of both the Ramey case and the Angoko case that jury's fact finding is and can be affected by the set of verdicts available to them. And so I think whereas here, they did not have the ability to find a robbery without finding a deadly weapon, it is wholly consistent with the Angoko and Ramey cases to...
Hasn't the legislature made just using a deadly weapon, having it in your hand, sufficient for the conviction? No matter how you use it, if you have it.
I believe with respect to it being apparently a deadly weapon, and this may be opening up a can of worms, I think a proper jury instruction on that would need to say that it is apparent that the three elements of the definition of a deadly weapon are met. That is, that it is apparent that the defendant knew that it was capable of causing serious bodily injury or death, that the defendant, that it was apparent that the defendant intended to use it in a way that was deadly, and that it was apparent that it was being used as a deadly weapon. I do want to point out that we are only saying it was rational for the jury to find that the bat was used as a weapon without being used as a deadly weapon. We're not saying that they couldn't find the deadly weapon on the evidence. Really, it's what the government is asking for is the much more serious holding that it is per se always a deadly weapon if it's a weapon.
right.
Thank you.
Your time's up. Thank you, councils. The court will take the matter under advisement and will now stand adjourned. We agreed to be able to have